On behalf of the Brennan Center for Justice, welcome. The Brennan Center is a nonpartisan law and policy institute affiliated with NYU Law School, and I'm Alicia Bannon, the managing director of the Brennan Center's Democracy Program, where I lead our FAIR coursework. And we are delighted to welcome you to the second day of a two-day convening on issues of workplace equity and accountability in the judiciary. The judiciary isn't only a legal institution, it's also an employer, and clerkships are often a pipeline to leadership positions in the law. In today's panel, we'll be discussing diversity and law clerk hiring, and you can also access yesterday's panel, which addressed sexual and other forms of harassment in the judiciary via YouTube and on the Brennan Center's events page. This Brennan Center event is co-sponsored by the National Women's Law Center, the NYU Law Review, and the NYU chapters of the American Constitution Society, the Latinx Law Students Association, the South Asian Law Students Association, and the Black Allied Law Students Association. We also want to extend a sincere thank you to those who helped plan and shape this event, including Jana Edelstein, Caroline Fredrickson, Emily Martin, and the Brennan Center's events team, Melanie O'Keefe and Adrian Yee. I want to invite those listening to share your questions for our guests by typing them into the Q&A box, and we'll take as many of them as we can during the panel. For those of you who are seeking New York State CLE credit, we will be sending at least one unique code into the chat during the program, so please write those down as they come up. You can find the link to the attorney affirmation form and the associated readings in the Zoom chat, as well as on the Brennan Center event landing page. And if you have any questions, you can contact cle@brennan.law.nyu.edu. And now I am delighted to turn things over to our moderator, Caroline Fredrickson, who is a distinguished visitor from practice at Georgetown Law and also a senior fellow at the Brennan Center for Justice. Thank you so much.
Right. Well, thank you so much, Alicia, and thanks to the Brennan Center for putting on this incredibly important event, along with the National Women's Law Center and our other partners. It has really, I think, been an extraordinary process of coming together to examine these issues. I know we're going to have a great conversation today. Yesterday's was really stimulating. I think today's will be equally so, and they're an incredibly important complement to each other, to thinking about what is the experience of law clerks and hiring and actual employment, and what are the actual, what's the data about law clerks. We don't know a whole lot, but we'll know a little bit more after today's conversation. So I'm going to very briefly welcome our esteemed panel. You can find in the event information longer biographies, so I'm just going to give a quick title, and each of the speakers, well, they're well known to this audience in any case, but I think you will learn more about them as they speak. So we're joined by Molly Coleman, who's the executive director of the People's Parity Project, Justice Goodwin Liu of the California Supreme Court, Jocelyn Fry, who's a senior fellow at the Center for American Progress, Amrita Malik, who's the Diversity, Equity, and Inclusion Officer at the United States Court for the Ninth Circuit, and Natasha Merle, who's senior counsel with the NAACP Legal Defense Fund. You know, we obviously have an incredible group of people here gathered together and an incredible audience. And so for that incredible audience, before I go any further with opening this panel, I do want to mention once again that if you're seeking CLE credit, you should record the following code on your affirmation sheet in order to verify your attendance. That code is 3QJRZJ. Again, the code is 3QJRZJ. Number 3, Quebec, Juliet, Romeo, Zulu, Juliet. So I hope you got that. Very important for your CLE credit. I know a lot of you are interested in that. Okay, we're here to talk about clerkships. Now, this is an incredible experience for a young lawyer. They're prestigious positions where a law clerk is often engaged to provide legal assistance and counsel to a judge. These are often the launching pad for a young attorney as they begin their career in the law, no matter what direction they go. They could become a practicing attorney, a law professor, or a future judge. Yet, as far as we know, there is little demographic diversity among law clerks, including at the federal level, or maybe especially at the federal level. And those who do reach chambers may face discrimination based on their identity. However, many groups, attorneys, law students, activists, are trying to overcome these hurdles. So the first real question that we want to address today is to try and understand what we do know and what we are trying to know. So there clearly there is a lack of good evidence about the composition of the law clerk workforce, but there is some knowledge and some who are very determined to make more information available. So what do we know about the scope of the lack of racial, ethnic, and gender diversity among law clerks? And how can we make this issue a priority? So this is a general question for all of the panelists. And I guess I'd like to ask any one of you, but maybe Amrita, since you're the diversity and inclusion officer for the Ninth Circuit, what do we know about what we don't know?
That is a great question. Excellent framing. I wanted to start off by acknowledging two things. First, about the judiciary. The federal judiciary's 2020 strategic plan, for the first time, really identified as a core institutional value diversity and respect, and then articulated as a specific goal the need to recruit, retain, and support a diverse workforce. So really looking at the idea of the judiciary as a major employer and what can be done, what should be done, what needs to be done to diversify the workforce. And law clerks are very much included in that. The second point I want to make is, as a result, just back up, that's sort of what led to the creation of my position, in fact, and I'm the first of my kind throughout the circuits, hopefully not the last. And in addition, we are, through the Office of Fair Employment Practices, currently collecting data on our existing workforce, again, including law clerks. So using a self-identified demographic survey model, we are starting to get that information. In conjunction with that, the Ninth Circuit Fairness Committee, which I'm fortunate to support, created a survey that was issued last year and collected data from current and existing law clerks throughout the Ninth Circuit. So looking at every level, from circuit judges to district to magistrate, bankruptcy, et cetera. And again, using a self-identified demographic survey model, invited our law clerks to tell us, what about your identity do you consider makes you an underrepresented law clerk? And the great thing about that is we got data not just about sort of your traditional equal employment opportunity categories, meaning race, gender, religion, et cetera, but also our law clerks told us things that they felt were important. And so we heard things about being a first generation student. We heard things about being a low income student or being from a geographically sort of isolated area, such as Appalachia. And that really helped broaden our sense of what diverse means, which I think is always helpful to the conversation. And again, we're starting to get that data. The data collection closed last December, and we're starting to put that together. But that's helping us really understand the challenges that our law clerks have faced and continue to face, and will help design interventions to better support that and really hopefully change and normalize our practices to look more broadly, encourage a broader applicant pool, and to better support the diverse and dynamic group that we're bringing in.
Well, Amrita, that's really incredibly interesting. And I know there are other efforts to gather such information. I'd love to hear about whether any of the other circuits are doing the same kind of demographic survey. But maybe Justice Liu, I'll turn to you, since you yourself are engaged in a major project that is along the same lines. Can you tell us a little bit about what you're doing what you're doing in terms of gathering data about law clerk diversity?
Sure, happy to do so. And thank you so much, Carolyn, for having us on this panel. I'm very delighted to join it and to do it with the Brennan Center. So I have been working on various issues in diversity in the legal profession for quite some time, and most recently working on a multi-part project with the American Bar Foundation and with my partner, Judge Jeremy Fogel, the former director of the Federal Judicial Center, on a somewhat wide-ranging study of diversity in the law clerk space. Let me begin by addressing your first question about what is known. The difficulty, I think, in this area is that not much actually is known about law clerk diversity. You know, some people may know occasionally Tony Morrow, who used to write for USA Today and now writes for Law.com and other audiences, would collect data on Supreme Court clerks, which is a small group, and he would publish, you know, diversity statistics for that select group. But beneath that level, across the wide range of federal circuit courts and federal district courts, I'm not aware of any publicly available source of real-time data year to year that tracks the basic demographics of those positions. So at any given time, we don't know really basic things like how many men and women are clerking. And so I think, you know, some of the steps that Amrita just outlined are very positive in beginning to put forward a basic database, evidence base about the status of diversity among federal law clerks. It's the same actually at the state level, where I think practices vary quite a bit from state to state. There have been some data collection efforts sporadically here and there, but nothing that I know of that is systematic and aggregative. So one piece of information that we do have is from the National Association of Law Placement. And what they do is they do a survey every year of what graduates from law school are doing 9 months out. That gives you a snapshot of what recent graduates are doing. That is not equivalent to a snapshot of who is clerking at any given time, because as we know, people clerk at different stages of their career. Some people right after law school, which is what NALP would capture, but many people, you know, sometimes do more than one clerkship, so that's beyond the 9-month window, and then some don't clerk for 2 or 3 years until after law school. But what they have found, at least among their recent grad data, is a pretty big disparity between the demographics of law school graduates and the demographics of clerks. So for example, students of color comprise almost 1/3 of the graduates of 2019 law school, but they are just over 1/5, 21% of the federal law clerks. And if you break this down by specific groups, all those disparities still arise. We looked at these data 3 or 4 years ago and compared law clerk demographics with the demographics of graduates of the top 30 schools, just on the theory that those would be the schools that supply the most clerks. And we found similarly large disparities. At that time, we found that 80% of law clerks were white, according to the NALP survey, even though 60%, they comprised only 60% of the top 30 law grads. So these are pretty big disparities. And I'll just say that, you know, one of the parts of our effort is a series of interviews that Judge Fogel and I have been doing to understand better judges' hiring practices. So let me just describe really quickly, and then we can spend some time later in the discussion about what we've been finding. But we have at this point interviewed almost 50 active federal circuit judges in confidential one-on-one interviews, each 1 hour, facilitated actually by the pandemic in a way, because we've done them all by Zoom. And we sampled a very wide range of judges, Democratic and Republican appointed, geographically diverse, diverse by age. We only were interested in folks who had had 3 years on the bench or more. So it was a very wide range. And we heavily oversampled minority judges, both because there aren't that many of them, and because, as we quickly found quickly into the study, some of their hiring practices really differ from what you might think of as the conventional norm. So I think we will finish that study this year, and we'll have some interesting things to report, hopefully by the end of the year. And I'm happy to preview some of them in this discussion.
Well, thank you, Justice Liu. It's so nice to see you on this panel, and it's so exciting to hear about this research. And you know, I think it may be really astonishing to a lot of people listening to this discussion to find out that how much we don't know. The fact of how little information is really collected, and that it has relied on efforts like those of Justice Liu and Amrita Malik to sort of jumpstart information collection doing something that the federal courts aren't, that will now in the Ninth Circuit doing for themselves, but not in a global way. And Justice Liu with Judge Fogel, really, I think engaging in an incredibly important examination of the hiring practices of different judges. And, I'm looking forward to seeing that data and understanding what it is that judges of color are doing that's different, and how they're addressing the disparities perhaps that they're getting in the candidate pool. We'll talk later about what law schools can do and what's going on the supply side. But I know that CAP is also been doing similar research. So I want to turn to Jocelyn Fry with the Center for American Progress to talk about the kind of data that the CAP has found, and ask you also, Jocelyn, to say, have you in your career looking at demographic diversity in the legal practice, do you see anything that's particularly striking in the law clerk data that's different or similar to the rest of the legal field?
Well, thank you for the question, Caroline. And it's great to be here with such a wonderful panel. And I really will just piggyback on what Amrita said and Justice Liu said, which is, we have certainly tried to dig into this question. And we have approached this issue primarily from looking at the issue of judicial diversity. And what we know is that if you look at the data, it is increasingly true, actually, that many judges have had themselves clerkships, federal clerkships. If you look at data, I think looking at senior appellate judges, for example, a third of them have had federal clerkships. But if you look at active judges, it's closer to 2/3. So we know that access to clerkships is one of the pathways that is often a precursor to being able to access the courts as a judge. And we have been researching the issue of judicial diversity, obviously around the question of how do we make sure that our courts function properly. And what we have encountered is exactly what the first two panelists have said, is that, there's a lack of data. We need better data. We ought to be collecting data real time on who actually are able to access clerkships. And to the extent that we know, for example, from the data that Justice Liu was referencing around the National Association of Law Placement, where there's a significant disparity between the graduates of law schools but yet the composition, the demographic composition of federal clerkships, that it says something about who's actually going to end up sitting on the court. And we ought to be able to know more about how that is happening, why that is happening. So, I wholeheartedly concur with the point raised about just the need to have better data and to make that a priority if we're really trying to ensure that our courts function fairly. I think the other thing that we look at around diversity is trying to figure out, what is the impact? What does it mean? Why is this valuable? And why should diversity even be a priority? And I think, at the risk of stating the obvious, we feel strongly that a diverse judiciary just helps our process function much more fairly. It helps ensure that you have judges who have a breadth of experience and who can bring those experiences to the bench. And, unfortunately, what we see just from the research that we've tried to do is that, the professional networks, the professional pipeline that gets to that enables, sort of builds our judiciary, is one that, increasingly just weeds people out. If you look at the data that is available, you see that looking at federal clerkships, for example, they're disproportionately male. They're disproportionately going to white applicants. And even even though there's been modest change, the change is really slow. And that has a practical implication ultimately on who not only goes before the court, who participates in the process of rendering decisions, and ultimately can affect, not only how our courts operate, but people's expectations of what the decisions and the renderings that the court will deliver. So, from our perspective, there's a lot more that we need to know about the diversity of clerks, but what we do know tells us enough that there's work that we need to do to broaden who accesses clerkships, and who's able to participate in those professional networks that make it likely not only that they get a clerkship, but ultimately may be able to be appointed to the judiciary.
Thanks, Jocelyn. And that actually makes me think of a few things that we could actually really dig into. And maybe I'll open this for Molly and in particular, and Natasha as a recent clerk. From the perspective of somebody applying for these jobs, the hiring system itself raises a lot of questions. Maybe system is not the right word. It's a bit of a black box. It's a hard thing for law students to crack, particularly when they may be first generation law students or even first generation higher education. So how does that process or system or whatever it is of getting a clerkship affect who actually applies? And maybe I'll start with you, Molly, and then we'll turn to Natasha.
Yeah, definitely. So before I dive into that, just wanted to take 1 second to piggyback off of some of the points that Jocelyn was making that I think are so critical to this conversation, and really made me think about the pieces of the data that we do have on the judiciary, which is about who our judges are. And I think we've seen a lot of talk in recent years about the need to diversify the federal bench, have more representation. The fact that we've never had a Muslim judge, Article 3 judge, the fact that we have an overwhelmingly white and male judiciary impacts the clerkship pool, and it impacts who sees themselves as a clerk, who considers applying. It also impacts hiring practices. Judges have, virtually no checks on who they bring on as a law clerk. And so if you have white male judges who see themselves in white male applicants, we're going to see these inequities perpetuated in the clerkships and in clerkship hiring. So I just wanted to flag that, although obviously we are not focusing on judges today. In terms of the current hiring system, so I think everybody knows that clerkship hiring is an absolute disaster. I graduated law school in 2020, so my class was under the federal judicial hiring plan. What that means is that my classmates weren't able to apply to clerkships until after their second year. This is a great start. Prior to the hiring plan being instituted, folks could come onto campus and be applying for clerkships as early as their first semester in school. We know that that is going to lead to inequitable outcomes. You have people who walk into law school day one, they had parents who clerked, they know what a clerkship is, and they are preparing for how they will get that clerkship. You also have people who come into law school who have never heard of a clerkship. If they've heard of a clerkship, they think that the name doesn't really explain what the role is. People are thinking that this is a fallback option. If you can't get a job as an attorney, maybe you can get a clerkship. If we don't give folks time to understand the system, to learn about clerkships, to learn about their value, we are going to continue to see inequities persist. So, these clerkship hiring plans, giving people a chance to really understand what it means to clerk, it's critical. It also means that people have longer to build up relationships with professors, people who come in without that network in place that we know some of the more privileged law students enter with. People have time to get used to law school, get used to how grading works, how law school exams work. We know that there are disparities in how people come in. And so the longer lead up that people can have before they start hiring, the better. Unfortunately, we know that these hiring plans aren't perfect. We know that judges aren't following them. We know that law students themselves aren't following them, and we know that professors aren't. And so thinking, as we'll discuss more throughout the day about the role of law schools, while law schools might not be able to control how judges hire, they do have influence over their students and they have influence over their faculty. And so really getting law schools on board with their need to and their responsibility to enforce these hiring plans is absolutely pivotal. The other piece of hiring that I wanted to bring up before handing it over to Natasha is something that I think is talked about less often is just how far out judges are hiring. So you have judges now who are hiring for 2023, 24, 25. Who knows what their life is going to look like 3, 4, 5 years down the road? The ability to commit to a position like that requires an immense amount of privilege and stability that not everybody has in law school. And so while we're thinking about how to change the system, I also think we need to think about what are the timelines that we're operating here on the back end and how can we make sure that people don't need to have their entire lives planned out for the next decade in order for clerking to feel like a feasible option for them. So we'll cut there and hand it to Natasha.
Thanks so much, Molly. And I did want to just put in what I think is always the ironic thing about the hiring process is that when people you'd think were most devoted to rule of law are completely lawless when it comes to the hiring process. And, you know, it is going to be an interesting conversation that we'll get into about how we can actually put some better rules around that. So Natasha, I'd love to hear from your perspective.
Yeah, sure. Thanks for inviting me and having this conversation. I agree with everything Molly said about the benefits of allowing law students to be in law school longer before the application period for applying to judges, and how that could perhaps help minimize the disparities and the privilege that you need to have in order to get one of these clerkships. You know, as we all know, law students come to law school with different foundation, not with the same exposure, not knowing how to, you know, navigate law school and the legal practice and necessarily what you need to set yourself up for a clerkship. And so I think it's, you know, really invaluable to kind of get all students kind of on the same playing field, on the same foundation. I know some institutions, law schools are better at this than others, but just exposing their students early on to what a clerkship is and why it's an invaluable experience. And kind of like Molly said, it's not just a fallback, but it's something that I think at least that most law students or all law students should be pursuing. You know, I know for me personally, and I think with Molly, who mentioned, you know, first generation higher education, or maybe Jocelyn, you know, for me, I know I was, you know, first generation higher education. I didn't know that there was supposed to be something that I was supposed to do in law school. Like, I didn't know I was supposed to be on a journal. I didn't know I was supposed to do certain things to set myself up. And I actually hadn't considered a clerkship. And it's not because I wasn't interested. It's just, I didn't really understand wholeheartedly what that is, what that meant, and what that could do for my career. And so it wasn't until a law professor, you know, just one law professor, that's all it took to pull me aside and say, hey, are you going to apply for a clerkship? And if you hadn't, you really should. And here is why. And so just having that one law professor pull me aside, kind of, you know, set me in my career on that on my trajectory. But it really shouldn't be ad hoc. It shouldn't be just, you know, it should be like an institutional, the law schools taking this on and ensuring that all their law students know about this and all their students have access to it. And not just, you know, the ones that have the highest grades after one semester or after 1 year. And those are kind of who are like handpicked who are going to be handpicked, you know, that the school is going to follow their entire education and ensure that they get the clerkship at the end of, you know, their time. It should be, you know, exposing students and giving them a fair shot at this great opportunity.
Well, thanks, Natasha. And that brings up, I think, you know, the kind of the other side. As I said, there's a supply side, the demand side. And, you know, I'd really love to hear from Justice Liu and from Amrita about, you know, both sort of at the global level of, you know, what is the Ninth Circuit doing to try and diversify its hiring pool and encourage a broader group of law students to apply. And Justice Liu, what have you heard from the original, you know, individual judges about their interaction with the process and what they're doing maybe to make it better for them? So I don't know, maybe Amrita, you want to start?
Yeah, no, thank you. And again, I apologize if my noise is a little bit crackly. I will do my best to clearly articulate these points. So I like the idea of thinking about the supply and demand side. So from the supply side, our survey data did show that students or clerks who consider themselves underrepresented did face three main challenges from sort of the support angle. And a significant area was lack of support or encouragement when they were in law school, not just from career services or clerkship staff, but also from faculty and students. And I wanted to share that 40% of our underrepresented students, so again, the students that identified, or the clerks rather that identified, said that they were actively discouraged when they were in law school from applying. And the reason this is so profound to me is the survey was of our successful clerks. These are the people like Molly, like Natasha, who were able to persevere. We don't even know who is being prevented from putting themselves forward for consideration beyond that, which I think is actually the population that we are more interested in reaching, frankly. But that is a big issue. So again, part of the goal of what the Ninth Circuit is doing with this survey is to help us build stronger relationships with law schools and to provide some helpful feedback about how law schools can be better supporting a more diverse group of applicants, encouraging people to consider the value of a clerkship and really sharing that information. You know, like Natasha, I was a first-gen law student myself many, many years ago, and I certainly came in not knowing anything about anything. And it has a very different impact moving forward and the way my career was shaped versus, you know, the fact that she did have a faculty member reach out to her. How can we encourage this and normalize that and standardize that process? And then I really would love to let Justice Liu speak, and then I'll ping back on that because I think we're both going to be sharing some points about what judges do in terms of intentional hiring practices that can shift the results for how they bring on diverse applicants.
Great. Justice Liu.
Yeah, this is a great discussion. First, let me just say that the way we kind of approach this general topic of thinking about you know, how to address this broad issue, we've thought about it really as kind of having three gateways or three buckets of inquiry. The first concerns the students. And we hear a lot about already on the panel, and certainly I've also heard it about self-vetoing, you know, students who just opt out of the process, or they may suffer information gaps, or they may be actively discouraged. And so one thing is to know from the student side what the process looks like to them, and to understand kind of both attitudinally, perceptually, what kind of barriers exist from their standpoint. And the second, and these are all related, the second concerns the schools. What kind of policies, what kind of practices are being used by schools to track, encourage, mentor, promote, you know, historically disadvantaged groups in reaching these opportunities. And so understanding that cluster of activity is also important. And that's the work we're doing with ABF. And then the third concerns the judges and their hiring practices. And I think these three, the students, the schools, and the judges, we have to think of this holistically because all three are important parts of the equation, and we can probably learn something about roadblocks to diversity from examining each. And there's also, I must say, just kind of a general tendency, not malicious in any way, but each of these kind of entities, you know, or areas tends to kind of point the finger at the others, right? I mean, if you ask, you know, some schools, they'll say, well, we just do what the judges tell us to do. Or if you ask some judges, they say, well, we can only hire the people that the schools send us. And the students say, well, we only take the signals that the schools, you know, send to us about whether we should apply. So every entity, you know, in the equation kind of thinks of the others as the responsible ones, when in fact, I think there is a more holistic picture, you know, that we need to develop. So let me just say that as a matter of context. In terms of the judges piece in particular, yeah, I mean, I think we're learning some interesting things. The first thing I would just say is that judges do think about diversity. Most of them do. And this is regardless of appointing president or party, region, age, across the board. People do think about diversity. This is part of the mindset. However, judges do conceptualize diversity in very different ways. You know, experientially, aspects of family background, even with respect to personalities and interests and hobbies and future ambitions, So diversity is a very broad word, and I think we have to be very sensitive in the conversation, and judges are very sophisticated people, that we're not overly reductionist in terms of saying racial or gender diversity. If what we mean is racial and gender diversity, we should talk about that. But if what we're talking about is diversity writ large, I think judges are interested in a broad range of intellectual background and also some socially salient and demographic diversity, but it's all one bigger conversation. And I think positioning it that way is really important if you want to have a fruitful dialogue with judges about this subject. Now, specifically with regard to racial or gender diversity, I think there, again, is a very broad range of views. Some judges actually don't believe that this does or should play any role in their decisions. Some of them even feel that it would not be lawful for them to take this into consideration. Others are on the far end of the spectrum are very intentional about it in thinking about their hiring. And there's a very broad range in between. I would say in the main, the median judge out there does care about this and is aware of it. I think it's hard what's difficult is for judges to know sort of what to do about it. I think, and we can get into that just a little bit more through discussion. But the last thing I'll say, so as to not take up too much time, is that a lot of the things Amrita is talking about, I think, are very interesting. Because one of the findings I think that we have is that judges themselves don't talk about this issue with their colleagues very much. And so culturally, as a matter of institutional culture, although individually judges are quite aware of this issue, and most of them, at some kind of basic level do care about it, it's not an issue that they talk about in a collective way. And this reflects in some ways the idea that clerkship hiring is not, it's viewed as an individual prerogative of the judge. And of course, I'm a judge. I mean, I think of it that way too. And in that respect, it's a hard thing to affect because the federal judiciary is not like, a corporate organization where you can issue an edict from the top and say, okay, we're going to affect, institutional culture, organization-wide in X, Y, and Z ways. It just doesn't exist in that way. And so in that way, it doesn't assimilate itself easily to the basic kind of EEO norms, that might exist in other federal agencies or outside of governmental organizations. So this is one hard nut to crack, is culturally how to foster a kind of a set of initiatives or a set of awarenesses or base of knowledge about this that could affect practice, while still, I think importantly, respecting the prerogative of judges to hire, in some sense, hire who they want. I don't think you're going to get buy-in really from the judges in terms of how to approach this issue unless you respect that basic prerogative. And so that therein, I think, lies the tension from a kind of organizational cultural point of view. And I think we'll have something to say about that.
So Amrita, I know you wanted to jump in again on this point.
I did, and I also wanted to go back and revisit. In the chat, I saw Lorna asked what the other two barriers are that were really highlighted in the survey. Just really quickly, it was lack of personal or social connections. Again, recognizing that a not insignificant number of our clerks got their positions because somebody made a call or somebody had a connection. And also, we lack of understanding and transparency of the process. I think Molly referred to it as a black box. She's not wrong. This is a real challenge for us in the judiciary in terms of, again, being more clear and transparent and working with our law school partners to make sure that everyone understands the pathways to clerkships. Shifting back to Justice Liu's point, I mean, I agree with everything. And I just wanted to echo that it's a very diffuse organizational structure with a lot of autonomy and power split up in different sort of collective places. And one of the powerful things about this conversation, about the survey, about things that we are doing, for the first time, there's a space for judges to say, oh, I thought this was important too. What are you doing? Or even judges who, I've never really thought about this before. What are people doing? Sharing that idea of best practices or things that are working for other people is really, again, inviting people into this conversation that didn't understand that they could have it. And happy to talk about that more, but I just wanted to echo that and say that I do think that that is a very positive step forward that I'm seeing, and that I think conversations like this will continue to encourage.
Well, and on that point, I think, I'd like to sort of take us in that direction. You've all talked about the different types of barriers, the lack of data, the kind of dispiriting data that we do have, the sort of the particularly particular situation of the judiciary and in its independence, and kind of the lack of a traditional EO structure, or even a possibility potentially, as well as the law schools. They have a whole bunch of other incentives. So yesterday's panel was a very good one in terms of talking about some of the what we could call perverse incentives of different players here, in terms of how law schools steer, don't steer law students to apply. And I think, Amrita, what you said to me, what you said earlier about the number of current clerks or recent clerks who said they'd actively been discouraged is way more discouraging than anything I had really expected to hear. I mean, that is information that is so incredible. So I'd love to turn to the issue of, both sort of on the supply side and the demand side. We've got some perverse incentives to some extent in law schools that, they kind of know what judges traditionally are looking for, and tend to favor those students who look like the ones that they got clerkships for the prior 100 years or 200 years. And the judges, similarly want to hire the top students, or, take the one, maybe it's easier. They have a trusted source at a law school. It gives them somebody they know they'll be able to work with, and they don't have to kind of dig through hundreds of resumes. We've got some incentives we need to change here. So, I'd love to really throw this open to any of you. But I think, again, I want to look mostly to Molly and Natasha here, to start off with your experiences with law schools, and, what maybe we could try and do with the law schools, but also speak to, since you're law clerks or recent law clerks, what do you think might work on the judges' side? And then everybody else can just jump in. Natasha, you want to start?
Sure. So I think, on the judges' side, like Justice Liu, mentioned, I think judges do have an interest in diversity, and I think we could talk about what diversity means, or how broadly we're talking about diversity. I think that there is some recognition or some interest in having gender and racial demographic diversity. I think if, the more we talk about this, and that's why I'm so glad we're having this conversation, the more we talk about this, and we could talk about the struggles, the burdens for people of color to get clerkships. And then when you do get a clerkship, the burdens and struggles you face as, perhaps the only clerk of color, or the only Black clerk, being more specifically, in your clerkship, or maybe even in the entire court house, talking about those difficulties, and also, just discussing, how that's detrimental to the, how that doesn't help, or how, you could further support or have better systems in place to improve that, and how that can improve the experience for everyone. So, I'm definitely a huge proponent of clerking. Every time I talk to law students, or even junior attorneys, I always tell them that they should seek out that opportunity. If they have any inkling of a desire. I clerked for 2 judges, and I think both experiences were invaluable experiences. But with that said, what I experienced as the only Black person at one point in the courthouse, Black clerk in the courthouse, and then one time just the only Black clerk in chambers, that there is difficulties that you encounter, and those difficulties are not any different than what we've heard students talk about as being the only person of color in classrooms, or even in other job sectors, being the only person of color, and feeling marginalized, or feeling that you don't share the background with your colleagues, and so dealing with those difficulties And I think the more we discuss that, perhaps we will have more people comfortable with discussing it and also more wanting to address that. And so I guess just one example, like, over this past year, our country obviously has been going through a national reckoning regarding police violence and discrimination against Black people. In the past year, I've heard from lots of Black clerks about the difficulties and the difficult conversations and the struggles they've been faced with in their chambers. It's not that they weren't having a great clerkship experience, but just, feeling that they had to be the person to speak out, or whether they shouldn't speak out and they should kind of deal with that, silently. And some Black clerks feeling like, well, maybe I should just leave my clerkship early, despite them knowing the benefits and the how this will help their career long term. I think that, hearing those struggles is nothing new. And I think, and like I started, I think, judges in general want diversity. And so I think if we can kind of focus on the benefits to everyone in the courthouse when you have more racial and gender diversity, and how that will help your colleagues and the people you're working with not have to face these barriers and these struggles alone, I think that, is something that people would want to consider.
Thanks, Natasha. I think that's a really important part of this conversation is it's sort of back to what Jocelyn was talking about at the beginning, which is, why is diversity so important? And here we have, an issue of the needing to talk more about the experience of Black clerks and other clerks in underrepresented populations and what their experiences are like, but also from your perspective, what a good experience it was and how beneficial it is to your career, and sort of a broader conversation about that in order to help, again, transform, I think, the types of incentives that we have for law schools, could be more sensitive about maybe both preparing law clerks, but also getting more law professors to do what your professor did, which is to reach out, be a mentor, and think about that role. So Molly, from your perspective, law school or judges' incentives for change?
Yeah, so in the last couple of years, we've just seen such an incredible amount of student organizing. And I think that, and I'll talk a bit about some of the challenges around student organizing when it comes to clerkships and to pressuring law schools to act on clerkship equity. But it's just been remarkable how much we are seeing law students lead the charge on making this profession better, leveling the playing field. We're seeing organizations like the National Disabled Law Students Association, which is leading the charge to make sure that disabled law students see clerking as an option for them and have that as a real meaningful option. We're seeing organizations like the diploma privilege organizers who are pushing to reduce what we know are racist gatekeeping mechanisms in this profession. And so folks who are really thinking critically about kind of at all levels of the legal profession, from the LSAT to clerkships and beyond, how do we make sure that everybody has an equal shot here? Because that's just not the case right now. So we've seen law students who are really thinking about generally, how can we push our law schools to take the information that we know, like, for example, that the first year grades are not reflective of people's abilities, that first year grades are more likely to, higher grades are more likely to go to white students, and think critically about how could law schools enact reforms kind of at all levels that will promote equity, not just in clerkship hiring, but across the profession. Law students are pushing on things like first year grades and mentorship opportunities and advising programming, and so far beyond that about how law schools can really engage on these issues writ large. That said, there are huge barriers to entry when it comes to clerkship organizing specifically, in part because what we were talking about earlier, how opaque this process is. The process is confusing even to the most privileged students at the top schools. So I think that when we think about who's influencing law schools and how are law schools engaging on this issue and how are students pushing them to engage, we have to be thinking about the fact that it's hard to know what the answers are here when it's almost impossible to understand the process at all. That said, obviously students recognize that there are massive inequities in clerkships and are really working to organize and to push their schools. In part, they're looking outward. They're looking to organizations, like the Appellate Project, like Clerks for Diversity, because they have more faith in these external organizations and that these orgs have their best interests at heart than they do in their own schools. And so I think that should be a fairly alarming sign about where students think their school's priorities are. And hearing Amrita say that we now know that schools are actively dissuading people from applying to clerkships, that's incredibly alarming. And I think shows why students are turning outwards. That said, I think that law schools have an ability and a responsibility to engage more on this issue than they are, and to stop kind of the finger pointing, to stop blaming it on judges, stop blaming it on the judiciary, and start thinking about their roles. Law school administrators are the ones working with judges to recommend and enforce hiring timelines. Career development officers, deans, other law school advisors are the ones maintaining databases of potential judicial employers and records of who from their schools have successfully sought and obtained clerkships. They're advising students on how to send out application packets. They're sometimes helping compile those application packets. They're exercising a pretty substantial degree of control over the kind of mechanics of the application process. And most importantly, law school faculty members are the ones recommending and referring their students to judges. So we've seen students push for kind of a number of reforms that their schools can make to ensure that clerkships are safe, which, obviously that was the topic of yesterday's panel, and really highly encourage everybody to watch that if you haven't already. But if students don't feel confident that they will be walking into a safe workplace, they are not going to pursue that path. And law schools have an ability to influence the safety of students' experience or clerks' experiences in chambers. So I think that students are calling on schools to do better when it comes to ensuring that people won't experience harassment and discrimination in chambers, and that if they do, they can get out safely. Students are pushing schools to think through how they're advising students. Are you really talking to students about how to turn down a clerkship if it doesn't feel like the right fit for you? How to have the hard conversations with former clerks to make sure that this is going to be an environment where you will not face harassment or discrimination based on your racial, gender, sexual identity, sexual orientation, etc. So, I think that there are a number of reforms that schools can make, a number of ways that schools can step up on this issue, but it starts with schools recognizing that they are a powerful player in this and not just kind of washing their hands of their responsibility to students and alumni when it comes to clerkships.
Right, Molly, thanks for that. That was really, really helpful. And you made me recall what I heard from somebody that it will go unnamed at a law school that will go unnamed about one of the things that they do when they hear about through their data that you're right to know that they collect, that they have information about who's clerked and clerkship experiences even. And in some cases, rather than making a sort of just suggesting that nobody apply to certain chambers because there's a problem, they might just direct certain students not to apply. And so make a situation for perhaps students of color or women students yet more difficult by eliminating a possible position for them rather than actually grappling with the issue because of the law school incentives and continuing to have clerks in those chambers. So, I mean, we all know possible examples of where this might have happened, but I think just how do we get law schools to start really grappling with their role? Is there a way to incentivize them to sort of towards the positive, perhaps not suggesting that there are places not to apply, but really highlighting good experiences, which I think could go quite a long way with what Natasha was talking about in terms of mentorship and help for the law clerks navigating the process that's already somewhat difficult. So before we go into any other questions, I do want to, it's time for me to read the CLE code again. So the earlier code that I read was 3QJRZJ. That's number 3, Quebec, Juliet, Romeo, Zulu, and Juliet, or 3QJRZJ. Now there's a second code. I feel like I'm sending secret messages or something. The second code is RGF DX6. That is RGF DX6. Romeo Golf Foxtrot Delta X-ray and the number 6. And somewhere in there, there's a message encoded that you'll all know as soon as you fill it out and get your CLE. All relevant CLE documents are at the link https:// or is that a / bit.ly/3 small b large v large P K X W. And if you have any questions and you didn't get that or you want to find those documents, just email cle@brennan.law.nyu.edu. So thanks. Sorry for the mouthful, but I know that CLE credits are a really important part of this conversation. So I wanted to just, before we go to any audience questions, I just wanted to see if any of the other panelists wanted to jump in on this issue of, kind of changing incentives for law schools and judges, and, what other possible reforms could there be?
Well, Caroline, I do want to just jump in really quickly and pick up on something that both Natasha and Molly said, because I thought that their comments were so important. And I do think, this idea that, the system is opaque, it's very diffuse, it's very mercurial and ad hoc, I think on some level obscures the fact that this is still a systemic problem, right? Like this is how the system works. And so, I think Natasha pointed out, the broader conversation about racial reckoning and systemic racism, systemic bias. This is on some level an example of it, right? Like we can't be confused by the sort of ad hoc nature of it, because that very sort of ad hoc nature is in fact a system that is biased and has been consistently biased. And I think the way you begin to fix it is you don't allow it to continue, right? Like you disrupt it. Are there questions that we ought to be asking of every nominee who's a judge about their not only their commitment to diversity in hiring, but their experience and their past practice in terms of diversity in hiring? I was struck by what Justice Lewis said about a wide variety of perspectives about whether diversity is even something to be valued when we're talking specifically about racial and ethnic diversity. So I think you tackle that head on when you're considering somebody for a position on the judiciary, if that is a value that you bring to the table. I wonder whether there are ways for courts themselves to help judges who say, I want a diverse pool, but I don't have the right, group of people, can you help me? Or are there ways for the courts to help build that pool to make sure that there is a diverse pool available? Those may be some steps that we can begin to take. But I tend to be somewhat pragmatic about this. You can't fix a problem if you don't believe that a problem exists. And once you recognize it, you also are not going to see change if you keep doing the same thing over and over again. So I do think we need to be, intentional about, are there, things that we can do just to change how the system operates so that we can inject more fairness into the process.
I don't know if any of the rest of you want to add to that, or I'll go to we have some really good audience questions.
I just wanted to jump in really quickly and echo what Jocelyn was saying. I think that that's a big part of, again, what the goal of these discussions are, to be sharing some specific ideas with judges that are interested, so building that capacity and sharing those tools. For example, looking at different practices and taking advantage of the fact that judges do have a lot of autonomy. Well, let's use that in a positive way for the judges that want to make that change. And before we move on, I just wanted to also piggyback on something Natasha said that I thought was really powerful, and speaking to the law clerk experience as an employee, and wanting to acknowledge that the judiciary is just starting to, but we are, and part of my role is to help create inclusive workplaces, and specifically for law clerks, very specifically for our law clerks of color. And how do we bridge that? How do we create opportunities for law clerks to interact more broadly, so outside of their chambers with each other, and help share their perspectives, again, more broadly, and inform the larger judiciary? So just wanted to echo that. I think that is critically important and a big part of actually the conversation that we are having as well. Again, how do we support people when we bring them on to ensure that they are safe and that they thrive and that we all get the best from each other?
Those are great thoughts. It's actually now going to lead into another question for you, Amrita, which and Goodwin should maybe Justice Liu. I'm sorry, I slipped. Old friends, we're old friends. To the issue of the gathering of data by the federal judiciary. First of all, I think just once again clarifying what is gathered and is what the Ninth Circuit is doing different from the rest of the federal court system, and what are the barriers, if any, to the disclosure and analysis of that data. And for Justice Liu, what do you know about this, but also what might you have found about the differences in hiring practices that the different judges have implemented? So two really, I think, important questions. So maybe we start with Amrita.
Yeah, sure. So with the creation of the Office of Fair Employment Practices within the administrative offices of the courts, within the past few years, really, we now have that data collection of existing employees. So again, we use our Form AO78 and we request our employees to self-identify their demographic data, again, kind of tracking the census data or the EEOC or OFCCP data that everyone else is collecting. So we are starting to gather that. The Ninth Circuit, what we're doing differently specifically with law clerks is gathering a broader set of diversity-related data for our existing and prior law clerks. So just to give you an example, we had over 700 responses to the survey that was sent out. So trying to sort of also be able to look longitudinally at trends in terms of what constitutes diversity and how that's been shifting. That's one thing that we are doing that I hope as we tinker with that and formalize that data and share it, that can maybe provide a sample or a model that other circuits can use. In terms of disclosure, I really can't speak to what's happening outside of the Ninth. Again, I'm very sort of responsible for this circuit. But I think that is a conversation that is happening. Again, right now we are rather new to the data gathering. It is happening, and we are then looking to best practices and what everyone else has been doing in other industries to help shape how we move forward.
Yeah, well, I think these are all very positive developments. And I mean, in some ways, it's kind of an interesting contrast because the data about the judges themselves is very meticulously gathered, curated, and published on the FJC website. You can, at any given time, go to that website and find all the data about federal judges, and you can sort them by race, gender, ethnicity, appointing president, I mean, all kinds of ways. So it's kind of interesting that that exists, but the information about clerks does not exist in a publicly available form. In terms of what we're learning, well, I think, so first of all, we're still in the process of parsing through all these interview notes, which are very voluminous and super interesting. Every single interview, we learn something different. I will just say that some of the vectors along which we have noticed differences, despite there being kind of a conventional view about federal, and we just looked at circuit judges. So keep in mind our universe is limited in that way because we just, I don't know, we needed a way to kind of limit what we were doing, and that seemed to provide more comparability in terms of what we defined. Despite there being a certain view about, grades being super important and whatnot, we actually found that judges have quite a large range of practices with respect to grades. Not all of them are just kind of like, I only take the top 10%, or you have to have this GPA or above, or you have to rank, et cetera. Quite a few of them go beyond that in a variety of ways. I wouldn't hazard a characterization at this point about whether it's most or some or whatever, but I would just say that there's variation. And part of the point of our study is to learn about variation, because you only learn something new about what can be done by looking at a few outliers, and not just people who follow what is thought of as the normal way. So that's one. Another is law schools. So it is true from other empirical work that has been done that a very small group of law schools, you can think of them as the T14, the T20, There are 25 schools that are ranked in the top 15. I mean, you know, the suspects do supply disproportionate numbers of clerks. That is true. However, we certainly found judges who hired from all over the place, actually, and that was super interesting. I must say, I confess, I'm as guilty of this as anyone. I think my hiring occurs within a fairly narrow band. It's partly conditioned by my own biases and by who I happen to know in the law school world. But some judges just have a very, very broad palette in terms of the schools that they're willing to consider and that they actually do consider. And there's something that we can learn, I think, from that practice. I think judges also have varying degrees of their actual practice of affirmative outreach, which is to say, most everyone, as I said, cares about diversity in some respect or another. With respect to race and gender diversity, I said, you know, there's a range of views. But if you ask the further question, you know, what efforts have you made, you know, to kind of get the pool that you want, right? I think everyone is actually, well, you know, the people who say they want diversity, they're very well intentioned and they're very honest, I think, about what they're after. But I think there's quite a range in terms of the degree to which people can sort of know what to do to actualize that desire. And you know, keep in mind, I mean, judges are busy people. They actually have jobs to do, you know, beyond just reading clerkship applications. And so part of it is trying to figure out how to make it, it's like a coordination problem, how to make it possible for judges who do want to achieve more diversity in their pool to actually get that. And I think that is actually not the easiest thing to do because signaling can kind of be tricky. You know, other than kind of, you know, individually one by one judges kind of doing this, which actually seems in a way quite inefficient, right? I mean, most organizations don't have individual managers just kind of like one by one saying, I want this, I want that. I mean, there's usually some organization-wide effort in order to leverage, right, the collective will for efficiency and for, you know, in some sense, more leverage in the process to get the pools that they want. And that just doesn't happen, right, in the federal judiciary, where every judge is, in a sense, his or her own boss. And so this is happening on a one-off, one-by-one basis. So I think just that kind of the coordination difficulty is something that is worth thinking about. And I know there's been efforts underway. The project, I think, Carolyn, you're probably familiar with Javaria Khan's project, the Appellate Project, and then many judges have mentioned the Just the Beginning Foundation. These organizations, I think, are filling a very important role in kind of identifying the pipeline, preparing students for it, and then from the judge's point of view, signaling, right? And so more of that kind of activity, I think, could really make an important difference. And, you know, in our study, we're not trying to, I should have said at the outset, we're not trying to convince anybody who doesn't, we're not trying to persuade judges who don't prioritize this to prioritize it more. That's not our objective. Our objective actually is more limited, which is to show, the range of practices out there, and for judges who do want to do something about this, to try to create some lateral, conversation, and as Amrita said, to create a space and then a shared base of knowledge so that this conversation can happen.
Right. Well, thank you. And we are running towards the end of our time. So I wanted to both give everybody an opportunity to say a closing remark, but also just to throw out a kind of a consolidated question from many of the people in the Q&A box have raised issues about, certainly one way of looking at diversity is some of the socioeconomic background issues that Justice Liu had highlighted earlier. So, what about how do we get both the law schools that are not in the among the top 20 that are in the top 10, or however you want to frame it, to encourage their students to apply? How do we encourage students who are not in the top 10% necessarily to apply, and why are grades why do grades continue to play such a role? And are there different ways of tackling this that might help diversify, both perhaps in terms of gender and race background, but also for those judges who are maybe a little less comfortable with looking at considering it through that lens, perhaps another lens would work. So all of that in the 3 minutes we have remaining for each of you to comment on. So I don't know who wants to jump in first to say a kind of closing remark. Maybe Molly, I see you looking like you're ready to.
No, I guess, closing thoughts on my end is just that I do feel optimistic, because I think that people are starting to see that we can't just say we want to increase diversity in clerkships, and we can look at that kind of in a silo and make it happen. What is incredibly hope-giving to me is the fact that people are seeing how we need to be focused on these issues throughout the entire legal profession. We need to be thinking about them in complicated and intersecting ways. And that, to me, is where we will reach a point where we have true equity representation in judicial clerkships and throughout the profession more broadly. So I do, while we've talked today about kind of the depths of the issues, the lack of information, and kind of how long and intentionally these problems have been going on, I do think that there's reason for optimism. I wish we would have had time to kind of get into the fact that the law schools, and the fact that when we're talking about federal clerkships in particular, we are talking about such a small number of schools, and schools that frankly are among the worst when it comes to racial diversity within their student populations. There's so much more we could have gotten into, but really look forward to continuing those conversations.
Well, Molly, that will be the next program we do. So that's absolutely a great idea. So thanks for being with us. And anyone else want to give us a concluding remark? And
Well, I'll piggyback on that, Caroline, and thank you for facilitating such a really thoughtful discussion. I will just reiterate something that I said earlier, which is that I think, there's no panacea to addressing this issue, but I do think you cannot address these concerns haphazardly, or just sort of hope that they fix themselves. I'm a strong believer in intentionality. And so if you see a problem, then I think you have to be pretty intentional about trying to address it. And I think, there are no perfect solutions, but there's certainly things that can be done at all levels. Even, if law schools, say to every student should have an opportunity to apply for a clerkship, right? Like maybe you should be telling every student who comes in the doors, here are 5 things that you can do, and one of them is pursue a clerkship, and centralize the process so that everybody has the same information. Should you be requiring every judge that comes on campus to fill out a questionnaire about their process, so that there is more transparency about the process that the judge uses? Are you asking judges when they, are being considered for the judiciary, how they value these issues? At every level, there are ways that you can be a little more intentional about, injecting the focus on diversity. And so I would just, support that and as a starting point. And I think that's where, that's the only way we can address the problem.
Great, thank you. I know, Natasha, you were ready to jump in, so.
Yeah, and I think letting Jocelyn goes first was even better, because, kind of piggybacking off of what Jocelyn said about being intentional, I think that's really important. Again, I had a great clerkship experience. Can't recommend it highly enough, but I'm wary if we say, kind of let judges do what judges are going to do, if we're not as intentional about it. Again, my concern is the impact it has on clerks of color, and in particular Black clerks. And so, for example, an example I didn't get to share earlier, what does it feel like to be in a courthouse where the only Black clerks are hired by Black judges? And does that mean that there's something different about us? Was there something, what was the reason that, a Black judge could find 2 or 3 qualified clerks of color, but other judges struggled to find even one clerk of color that they felt was qualified enough. And so that, Black clerks will tell you that has an impact too. Like, why is it that we're kind of separated and that we're only qualified, not only, but sometimes it could feel like we're only qualified to clerk for some judges, or some judges think only some judges consider us qualified. And so that's why, back to Jocelyn's point, I think it has to be intentional, and we need to have the space to have the conversation. And I'm concerned if it's only left to, will certain judges care about it or intentional about it or doing it, and some judges don't. And then I guess to your question, Caroline, that you mentioned about grades, or the omnibus question you had, I don't think I have a direct answer, but somebody did put in the chat about clerking a few years out of law school. And I would highly recommend that. My first clerkship was immediately out of law school. My second clerkship was maybe 4 or 5 years later. And I think my second clerkship experience was a lot different, just because I felt I had more tools. I knew what I was doing more. I felt more confident in analyzing legal issues, that I could engage in conversations with my judge and, have little debates with my judge. So it was just a different, both experiences were great, but the second experience, I felt more empowered, and I really enjoyed that experience. So to the extent you don't get a clerkship right out of law school, or if you just decide you want to wait, and I know some judges do value clerks who have work experience, I would say definitely encourage, and law school should still support those students who decide to wait to clerk maybe 2, 3, 4 years after law school.
Right. That's actually a really important point. So Amrita and Justice Liu, I leave it to you to end our panel for today.
Well, I'll jump in so I can let Justice Liu close us out, because he'll do a much better job. I want to, again, just echo Jocelyn and Natasha in intentionality. Just with specific examples, we have a judge in the circuit who guarantees an interview to every applicant who is top of his or her class, or their class, regardless of what school they went to. We have other judges who very actively recruit outside of the T14. And I think it's just a matter of, what I'm really trying to say is we need to broaden how we define excellence and how we measure excellence in our law clerks. And again, we also have a circuit judge who treats it like the NFL draft and uses Oscar to sort top 10%, boom, right? So again, getting beyond that and really being more mindful about what makes a successful clerk, what are we looking for, and broadening our perception about who will serve that, who will that person look like. So with all that in mind, and again, I think we start where we are. We start with the people who are doing it, who are being intentional, who are developing those best practices that we can share out. And then the hope is then to start to institutionalize it and to address it in a way that becomes standardized and normalized and not so haphazard, which is the system we do have now.
Right, thank you. And Justice Liu?
Thank you so much, Caroline, and the Brennan Center for doing this program. I think this program itself and so many of the efforts that surround it are just a positive step forward in terms of advancing this conversation, which for many years actually didn't even exist, like in the form that it's existing now. So I share Molly's cautious optimism that we will be able to make a few steps forward on this just by bringing these issues more prominently to the fore. I'll just say that by way of conclusion that, my thought on sort of theory of action, there's so many moving parts that are necessary, but at the end of the day, I think judges are, obviously they're in a very unique position in our society, and they're in a unique position with respect to the way in which they hire. And so if we can bring more judges into conversation with each other, I think that's the most persuasive way that you're going to be able to make change. And in some sense, the 50 interviews or so that Judge Fogel and I have conducted, my wish, of course, we're not going to do this because of requisite confidentiality concerns, but my wish was that other judges could hear the things that we heard, because I think they would find it so interesting to know the way in which their colleagues struggle with this issue and the way in which some of them, have done something about it. And I think in that way, the shared learning and it's not even persuasion. I would just say that it's a way, it's the peer contact, I think, is so essential to actually moving the needle on this. And that's, I think, what we hope we'll be able to do along with the collaboration of all of the efforts that have been discussed on this panel in creating the space for that kind of conversation going forward.
Great. Well, thank you all. And we'll celebrate, I hope, moving the needle through all of your collective efforts. And I want to just, thank the audience. And one more time, a quick read of the CLE code. I think just before you all jump off, those of you who need CLE credit, it's 3QJRZJ and RGF DX6. And the CLE documents are at https://bit.ly/3 lower b capital V capital P KXW. KXW are lowercase. So anyway, thanks everybody, and look forward to the next conversation about law clerks and diversity and hiring, and appreciate you all participating. So thank you.
Thank you.